The Judiciary Act of 1789 was signed into law by President George Washington on September 24, 1789. Article 3 of the Constitution established a Supreme Court, but left to Congress the authority to create lower federal courts as needed. Principally authored by Senator Oliver Ellsworth of Connecticut, the Judiciary Act of 1789 established the structure and jurisdiction of the federal court system and created the position of Attorney General. Although amended throughout the years by Congress, the basic outline of federal court system established by the first Congress remains largely intact today. The act set the number of Supreme Court justices at 6, 1 Chief Justice and 5 Associate Justices. The Supreme Court was given exclusive original jurisdiction over all civil actions between states, or between a state and the federal government. The court was given appellate jurisdiction over decisions of the federal circuit courts as well as decisions by state courts. The act also created 13 judicial districts within the 11 states that had then ratified the Constitution. This act established a circuit court and district court in each judicial district. The circuit courts, which comprised a district judge and 2 Supreme Court justices, had original jurisdiction over serious crimes and civil cases of at least $500. The circuit courts also had appellate jurisdiction over the district courts. Congress authorized all people to either represent themselves or to be represented by another person. The act did not prohibit paying a representative to appear in court. The act created the office of Attorney General, whose primary responsibility was to represent the United States before the Supreme Court. The act also created a United States Attorney and a United States Marshal for each judicial district. The Judiciary Act of 1789 provides jurisdiction in the district courts over lawsuits by aliens for torts in violation of the law of nations or treaties of the United States, due to the Alien Tort Statute.